Hello, everybody. I'd like to welcome you to ACS's annual Supreme Court preview. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. And as I think most of you know by now, ACS was founded in 2001, and it's a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping the debate on vitally important legal and constitutional issues, such as the ones we will discuss today. But before we go into today's conversation, I did want to just pay our respects to a dear friend, to ACS, to the progressive legal community that we lost. Doug Kendall, who was the founder and president of the Constitutional Accountability Center, who's a brilliant thinker and a strategist, but most of all, a warm and compassionate individual who cared deeply about this country and our values and the direction we are going and our understanding of our Constitution. So I just wanted to take this time to thank him for all he did and to remember him in our hearts. It's a very sad moment for those of us who are close to Doug. But Doug would want us to get on with this conversation as we talk today about this year's Supreme Court term. The Supreme Court is about to get back to work. And as many of you know, today is the Justices' annual long conference at which they will review the petitions that came in over the summer. And of course, we know some of the questions they will take up: the death penalty, affirmative action voting rights, the ability of public employees to bargain collectively and effectively, and other important cases that will impact worker and consumer rights. And looming on the not-too-distant horizon is the possibility that the court may take up challenges to a Texas law that restricts women's access to abortion, and to the DAPA program, the president's executive action deferring the deportation of certain undocumented immigrants, and not to mention the ongoing dispute over the availability of contraceptive coverage under the Affordable Care Act. To lead us through our discussion today with our distinguished panel, we have a true expert on the Supreme Court, Amy Howe. She is no stranger to court watchers. Amy is the editor of and a reporter for SCOTUSblog. Her live reports are what we wait for with bated breath at the end of every Supreme Court term as decisions are handed down, as we all gather around our computers and wait for Amy to tell us what's happening. Amy has served as counsel in over 24 merits cases at the Supreme Court and has argued 2 cases there. From 2004 until 2011, she co-taught the Supreme Court litigation clinic at Stanford Law School, and from 2005 until 2013, she co-taught a similar class at Harvard Law School. She's also served as an adjunct professor at American University's Washington College of Law and Vanderbilt Law School. Amy is a graduate of the Georgetown University Law Center. And I'm very pleased and hope you will join me in welcoming Amy Howe today.
Thanks very much, Caroline. Today, you're not going to be hearing from me about what's happening at the court. You're going to be hearing from our panel of experts who know way more about these topics than I do. I'm going to introduce each of them, and then we're going to start talking about the cases at the court this term. We'll spend a little bit of time, if we have time at the end, talking about a couple of issues that are likely to be at the court this term, and we'll try to save about 15 minutes for your questions. So on my left is Kannon Shanmugam, who is a partner at Williams & Connolly. Before he was at Williams & Connolly, he spent several years as an assistant to the Solicitor General there, and he has argued 17 cases at the court, including the landmark DNA case, Maryland versus King. It is also his first appearance at an ACS event today, so please be kind. On his left is Ann Hodges. I was delighted when I was looking her up today on her website at the University of Richmond to realize that she is a fellow graduate of the University of North Carolina at Chapel Hill. She's now at the University of Richmond, where she teaches labor and employment law. On her left is Alan Morrison, who's the Lerner Family Dean of Public Service and Public Interest Law at the George Washington University Law School. He has argued 20 cases before the court, and if any of you have either been in or taught constitutional law, you'll be very familiar with one of them, which is INS versus Chatham. So welcome, Alan. On his left is Deborah Archer, who is a professor at the New York Law School. Before she was became an academic, she was at the NAACP Legal Defense and Education Fund, where she litigated, among other things, affirmative action cases. And then on the far left is David Cole, a professor at Georgetown University Law Center. He too has briefed and argued many cases at the court, including Holder versus Humanitarian Law Project and the National Endowment for the Arts versus Finley. So I'm going to kick it off talking to Deborah about a case that many of you are going to say, oh, that case again? I thought that case was over. It is Fisher versus University of Texas at Austin. There's no truth to the rumor that the plaintiffs are now actually Abigail Fisher's children. So Deborah's going to go ahead, and then we'll open it up to our panel.
Hi, everyone. Thank you, ACS, for having me up as part of the panel. And yes, for the second time, the Supreme Court is going to assess the University of Texas's race-conscious admissions program. And a lot of folks were surprised because here it is 2 years later. Abigail Fisher has graduated from Louisiana State University. She is happily working in financial services in Texas, but here we are. And what is at issue is really not whether a university can consider race as one element in a holistic, individualized review admissions program, but whether or not the University of Texas can consider race as one factor in its individualized review program, given the existence of the Texas Top 10% plan. In 1997, after the Fifth Circuit decided Hopwood v. Texas and banned the use of race in admissions programs, Texas implemented the Top 10% plan to try to help maintain some level of diversity at its state institutions. And the way that plan works is that if you are in the top 10% of your graduating class in Texas, you are guaranteed admission to the state's colleges and universities. At UT, approximately 80% of its entering class is admitted through the Texas Top 10% plan. After the Supreme Court decided Grutter and said, yes, universities are allowed to consider race as one element in a holistic, individualized review, UT adjusted its program, and now in that second, the 20% that's left, they do consider race as one factor in admitting its entering class. Abigail Fisher is challenging that supplemental program that they use for that 20% and the consideration of race there. Her arguments are that the use of race can't withstand strict scrutiny under equal protection analysis because even if diversity is considered to be a compelling interest, what the University of Texas is doing is not pursuing diversity, but pursuing racial balancing. And she also argues that they can't meet the narrow tailoring component of strict scrutiny because they get their diversity through the Texas Top 10% plan. So during its first time through the court, as many of you will remember, the district court and the Fifth Circuit upheld Texas' program at the summary judgment stage. When it got to the Supreme Court, they remanded it back to the Fifth Circuit for what they considered to be a more rigorous application of strict scrutiny and to determine whether or not they could get sufficient diversity without the use of race in this supplemental program. On remand, the Fifth Circuit again upheld the University of Texas's program, and here it is in front of us again, in front of the Supreme Court again. Although the fundamental overall issue remains the same, the University of Texas is taking a different approach this time around in defending its program. The first time around, the University of Texas focused on the need to use this supplemental holistic review program to get a critical mass of underrepresented minority students, particularly Black and Latino students. So through the Texas Top 10% plan, they were getting 3% of Black students, for example, in their entering class. And they said that wasn't a critical mass, and so they needed to use race as a factor to get them closer to critical mass. Of course, they never defined what critical mass was, but 3% wasn't it, so the program was necessary. They also argued that the program was necessary to achieve diversity in specific programs and classes, particularly smaller seminar classes where the actual discussions and robust exchange of ideas takes place. For reasons that are not yet crystal clear, they're switching up their approach this time, and they're not so focused on the number of students of color admitted through the Texas Top 10% plan, but who those students are. Some people are calling this a qualitative focus as opposed to a quantitative focus. They're focused on the quality of the Black and Latino students who are admitted through the Texas Top 10% plan. And this all occurs against a backdrop of questions around why the Top 10% plan works and why we're getting diverse students through that program. And really it works because there's deep residential segregation in Texas that results in deep educational segregation in Texas, which results in single-race high schools. So if you attend a predominantly or 100% Black or Latino high school and you do well at that school, you're going to get admitted to the University of Texas. And what that results in, kind of focusing on Black students, for example, is that the Black students who are admitted to the University of Texas through the Top 10% plan are predominantly from low-income families. They live in segregated, poor neighborhoods. They attended segregated and under-resourced schools. And as a result, they're coming to the University of Texas not as prepared for college as other students. University of Texas has presented some evidence to show that, in contrast, the students admitted through the holistic review process are more likely to be middle-class students, more likely to have attended integrated schools, and more likely to be better prepared for the college experience. So it's really unclear how this is going to play out for the University of Texas. They're focused on not just diversity, but what people are saying is diversity within diversity, intra-group diversity, and arguing that the holistic review program is necessary to get the educational benefits that come from having that diversity within diversity. It's not clear what the court's going to do, one, because that argument, to use a technical term, is a little mushy. Not sure what all of that means is going to turn out to mean, but also that it's not really clear that Grutter recognizes this diversity within diversity interest. In terms of what the court might do, it's difficult with Justice Kagan recusing herself again and 5 other justices having repeatedly voiced their reservations about the use of race in these contexts. But the court will definitely have to go into the merits a little bit more than they did the first time around. I think it's unlikely that they will do anything to get rid of Grutter. They've upheld it several times, and actually Grutter is not directly attacked in this case. But I do think they may make it difficult to meet the standard in Grutter, and that's going to have an impact on 2 other cases that are working their way through the system, one against Harvard University and one against the University of North Carolina. The court could make it very difficult for those cases, which I think present a more direct threat to Grutter. The court's likely to also revisit critical mass, what it means, and whether or not the University of Texas has or has not achieved a critical mass of underrepresented minority students. And I think the court, in the end, is likely to strike down the University of Texas's program on the narrow tailoring grounds of the test.
Thanks, Deborah. Alan, I know you wanted to chime in.
This case is full of ironies. Starting with the fact that the people who most are interested in striking this down are the people who've been most aggressive in finding lack of standing. Miss Fisher, of course, doesn't want to get to the University of Texas anymore. Her only claim left is for $75 in damages for her admission fee. It's pretty clear from the record that even if she'd gotten a perfect score or no score, race factor had been taken out because of the way they do their admissions, she wouldn't have gotten admitted. on the one hand, the proponents at the university say, well, this only affects 2 or 3%, and they say, so therefore it can't be very bad. On the other hand, the opponents say it only affects 2 or 3%, and therefore it can't be very good. So it's hard to know what's the big deal and who has to win that argument. The top 10% is actually kind of interesting. It's not the top 10%, it's only the top 10% of A, public schools, B, in Texas, and C, for those who rank classes. Apparently, there are a significant number of high schools, not only in Texas but elsewhere, who simply do not, for pedagogical reasons having nothing to do with the Texas admission, refuse to rank students. If your high school doesn't rank you, you can't get in under the top 10% of a class. In some respects, this case was there before. They could have decided much of the same things they decided before, and it's unclear what they're going to do. They surely could have not taken this case and said, look, the record is very old. This relates to something that happened a long time ago. There was relatively little discovery in the district court, even though now the court would say we have to have a lot more facts. And all those arguments were made in the brief in opposition by the university. And so my sense is, as Deborah said, that they're not going to let this stand. And of course, what's hard to tell is what they're going to do. One of the things that the Fisher's lawyers are saying is, well, you couldn't tell us what the critical mass was, and so therefore you didn't articulate what your goal was supposed to be, to which the university replies, well, if we told you what our goal was, that would be a quota, and you would knock us out on that grounds as well. So it's kind of hard to see what's going to happen here, but it's difficult to imagine anything good happening unless they dismiss it as improvidently granted or being too hard.
I think you're right. There's a couple of issues where it's like Goldilocks, the porridge is too hot, it's too cold, it's just right. One is, as you mentioned, they're admitting too few students under this race-conscious program versus admitting too many, and that was an issue the court also addressed in parents involved in community schools, where they weren't admitting enough, so they felt like it wasn't necessary because it wasn't having a big enough impact. But you did say, again, that it's not clear why the court has taken this case, and I'm afraid that it is to impact the University of North Carolina case and the Harvard case. I think this court plays the long game, as they say, and sets up the stage, as they did with the voting rights. The case that they heard in Nemundo, they had set up the opinion we saw in Shelby. Justice Thomas did it before with the Second Amendment. So I'm sure that the opinion that we see coming out of the court on Fisher will have an impact on whether or not Harvard or University of North Carolina can keep their programs. The University of North Carolina's program is interesting to me because I think one of the motivations is that an admission official of the university allegedly said, we certainly could admit a whole lot more minority students if we had a top 10% plan, but we don't want to because it's going to lower the entering credentials of the class. And I think the plaintiffs have latched onto that, and I think may use it as use the case as a tool to have the court say that where you can use top 10% plans, you should try to do that before using race or using other factors that are substitutes for race first if you can. And with the Harvard program, it's a little more scary, I think, because they are actually directly attacking Grutter and the holistic review program, saying that they're using the holistic review program as a guise to cap the number of Asian American students that are admitted. So those two cases, I think, really do present more of a direct danger to affirmative action programs, and the court may be using Fisher to set up their opinions in those cases when they get there.
Texas said, why don't you use those other cases? Leave us alone. We've been up here once before.
That's for this preview in 2 or 3 years. Yeah. David and then Kannon. And then...
So I just wanted to add one more irony. An irony here is that the University of Texas, in its holistic review plan, has essentially adopted what the University of Michigan Law School did in Grutter after the Supreme Court upheld what the University of Michigan Law School did in Grutter. So the difference essentially between University of Michigan Law School and the Texas program is that Texas has the top 10% plan, and then with just a small remainder, 20% of their admitted students, they use the holistic review. So if it would be ironic to say it's perfectly okay to consider race with respect to every applicant who applies, but once you adopt the top 10% plan, you can't consider race with respect to the next 20. And one of the many ironies of that is that no sane admissions officer would adopt a top 10% plan, except for the fact that it gets you some racial diversity. That's the only thing that's good about the top 10% plan. Otherwise, it's a terrible way to choose an entering class. It doesn't look at anything other than your class rank. That's it, class rank, and that's just not, you know, how any admissions officer would want to sort of create a learning community, and yet they're driven there by this prohibition on race. And then the last thing I'd say is that I think that there's a fundamental tension in the court's affirmative action doctrine in this area. On the one hand, they say you have to apply strict scrutiny, which requires narrow tailoring of means to ends. On the other hand, they say you have to defer to the university's assessment of diversity and critical mass. And that, and both diversity and critical mass are, as Deborah put it, mushy. They're designedly mushy. They would otherwise be a quota. It's not about race. It's about looking at the whole person and taking race along with many other factors into account. And so you have at the end state something that can't really be specified, diversity and critical mass, and yet you have to apply narrow tailoring to this mushy, open-ended, indefinite goal. And there's just a tension there, and this case presents that tension as strikingly as any have. And in fact, the dissent in the Fifth Circuit said, his opening line essentially was, this critical mass diversity thing is too open-ended and indefinite to permit narrow tailoring. But in the Michigan cases, Chief Justice Rehnquist, writing in the Gratz case, which was the University of Michigan lower court case, said that this court has specifically rejected the argument that diversity is, quote, too open-ended, ill-defined, and indefinite to constitute a compelling state interest. So unless they're going to abandon that notion that you can use diversity as an end, even though it's open-ended, ill-defined, and indefinite, then it seems to me all you can require for narrow tailoring purposes is precisely what Texas has done. Try neutral things, don't use quotas, engage in holistic review, and use race only as a modest factor. That is narrow tailoring, and that's as narrow as one can get if you accept diversity as a goal.
All right, Kannon gets the last word on this one.
Well,
at least until the questions.
Thank you, Amy. And first of all, let me just say what a pleasure it is to be making my debut before ACS, an organization that is obviously committed to vigorous but civil discussion of legal issues. And at the risk of disappointing in my appointed role, I'm going to start by largely agreeing with Deborah and David. I think Deborah has really put her finger on what is so interesting about this case as it has evolved, which is the way in which the stated diversity rationale has really shifted towards this so-called qualitative diversity rationale, where the interest is not so much in the raw numbers of underrepresented minorities as it is in getting diversity within diversity, getting more minorities from what are essentially more affluent school districts. I think the stated rationale as the litigation has evolved has really been that the types of minorities that are underrepresented as a result of the 10% program are precisely minorities who come from more affluent school districts who might not quite make the 10% cutoff, but who therefore don't get in otherwise, and that there's a real need for these minorities. Now, why is the state advancing this rationale? Well, I think it is largely because, as David points out, I think there's a real tension between what the Texas legislature did in adopting this 10% program and the desires of the admissions officers at the University of Texas at Austin. I think given their druthers, if they were trying to achieve numerical racial diversity, I don't know that they would necessarily admit the minorities who get in through the 10% program, many of whom sadly come from school districts where the quality of the high school educations is not as high. And so I think in essence what is going on in these cases is that the state, what's going on in this case is that the University of Texas at Austin takes a somewhat different view from the view of the the Texas legislature, and they're really trying to ensure this broader type of diversity. Now, how that's going to strike a majority of the court, I think, is open to question, but I think that that is really what is going on here, and I think as a legal matter, what is going to be very interesting about this case is getting a sense of the extent to which the court is willing essentially to defer to the university and to admissions officers in their definition of the diversity interest, and whether the court is going to be willing to take these admissions officers at their word when they state that that is their rationale for all of this. I think the reality of this case is that I find it very hard to imagine that there's going to be a majority of what is an 8-justice court here to conclude that the Texas program is permissible. I think precisely because of the somewhat quirky nature of this program, where you have this sort of melange of the 10% plan and the use of race for only a portion of the class, that it is likely to be a relatively case-specific ruling, and it is unlikely to involve revisiting Grutter or sort of first principles of how affirmative action programs are assessed. But having said that, I am sure that the court is going to be aware of the fact that there are these cases involving Harvard and North Carolina that are coming down the pike, and I do think that the court's decision will be made with one eye on those cases. And just the last thing I would say is that, as Deborah points out, this case has this somewhat a tortured procedural history, with the court having sent the case back on fairly narrow grounds a couple of years ago. If you've read Joan Biskupic's book, I think her book on Justice Sotomayor talks about the history of the first time around, and it suggests that, in essence, what happened was that Justice Sotomayor had prepared a very stinging dissent. The court had been prepared to go further in invalidating the Texas program, and it sort of pulled back from the brink. But I think that the very fact of that history suggests that passions are going to run very high in this case. We saw those passions in the intervening decision in the Schuette case from Michigan, which involved a prohibition on the use of affirmative action, when Justice Sotomayor wrote perhaps her most passionate dissent since coming to the court. And I would expect something similar this time around, even if the court's decision ends up being relatively narrow.
Excellent, thank you. We are going to go to another case that, although this case is not, as the late Yogi Berra would say, deja vu all over again, the issue is one with which the justices and many of you are already quite familiar, and that's Friedrichs versus California Teachers Association. Anne?
Thank you, and it's a pleasure to be here. As Amy said, this issue is back before the court again. The issue that is before the court is a First Amendment challenge to California's Fair Share Law. And the Fair Share Law requires individuals who are represented by a union by law, where the union is required to represent them. The law requires them to pay the costs of that representation. They don't have to pay for political expenditures of the union, but they do have to pay the cost of representation under this law. This is an issue that the court decided in 1977 in Abood versus Detroit Board of Education. It was a very similar law from Michigan, and the court upheld it as against essentially the same First Amendment challenge. So one question for the court is, should Abood be overruled? And the subsidiary question, and I would suggest the kind of fallback position of the plaintiffs here, is whether the system, which is known as opt-out, meets constitutional muster. And this is, the opt-out system is one that all of these fair share laws use. And what it says is, if the union is representing you, you have to opt out of paying the political expenses, as opposed to opting into paying the full amount of dues. So the plaintiff's argument is it's a burden on the First Amendment rights to have to opt out of the system as opposed to having to opt in. A couple of really important facts here that I think sometimes get lost in discussions about fair share. This does not apply unless there is a choice by a majority of workers in a bargaining unit to have union representation in the first place. So this is a part of the exclusive representation system, which virtually all labor relations systems, sort of full-blown labor relations systems in the United States, have chosen, and that is a majority of workers determine whether the union will represent that group of workers. Once that decision is made, then the union is obligated to represent everyone in the bargaining unit, even those individuals who do not desire union representation. The contract that the union negotiates applies to everybody, and any grievances that are filed, in order to enforce the contract, the union is obligated to represent non-members just as actively, as fairly, non-discriminatorily as it does union members who are paying full dues. So as a part of this, states like California have passed laws that say, if the union is obligated to represent you, then you have to pay the costs of that representation. And that's what's known as fair share. And that's the issue that the plaintiffs argue burdens essentially their First Amendment rights, even though they do not have to pay for any sort of political activities of the union. They don't pay for lobbying, they don't pay for any sort of support of candidates. All of that you hear about that unions do is not paid by fair share fee payers. So why is the court reconsidering this issue? I think it's a matter of a change in the court and a change in the political climate for unions. There are two decisions where Justice Alito wrote the opinion in the last few years, one in 2012, Knox versus SEIU, and one in 2014, Harris versus Quinn. And in those two cases, Justice Alito's majority opinion extensively criticized Abood. And essentially, I think, issued an invitation to challenge fair share fees and seek to overturn Abood. And the plaintiffs here took up that invitation and brought this case to the court. It was brought to the court very quickly. The plaintiffs asked for judgment on the pleadings. There is no record in this case. It was judgment on the pleadings because they wanted to get the case before this court because of Justice Alito's earlier opinions. So I think that raises a particular issue, the absence of a record, because many of the plaintiffs' arguments depend on factual issues where there simply isn't a record. For example, and this is just one example, on the opt-out, opt-in issue, they argue that it burdens the First Amendment rights of the plaintiffs to have to opt out. Yet their complaint says these plaintiffs, there are 10 of them, have successfully opted out for a number of years. And the union's pleadings, which have to be accepted as true for purposes of this judgment on the pleadings, establish that essentially what you have to do to opt out is you get a notice, and the union is required to send a notice, you check a box saying I want to opt out, you send it back to the union, and the union doesn't charge you those non-chargeable expenses. And not only do they not charge the non-chargeable expenses, they build a cushion in. This union and every union that I know of, if, say, 80% of dues is chargeable, they will charge 75% of dues, just to make sure that there is no charge for any of those political activities. So that's one issue. I think the stare decisis issue is a significant one here too, because for years, states have established these labor relations systems in reliance on Abood. Remember, it was decided in 1977. So there are thousands of labor contracts covering millions of employees that have been negotiated in reliance on these fair share laws. And there are about 20 states that have fair share laws like California's. So there are very strong reliance interests there. And the dissent actually in Harris talked a lot about stare decisis and these reliance interests. And then as to the merits of the issue, essentially the plaintiff's claim here is that all collective bargaining is political in the public sector. Their argument is that any time you negotiate a contract, that's actually political activity. So even charging workers for that negotiation impinges on their First Amendment rights. But I think what the problem that runs into is a whole series of cases, some of them decided by this court, which give public employers very broad reign to restrict the speech of employees as employees. So the government as employer has much more freedom to restrict employee speech than they do to restrict the speech of citizens. So we have here employees then, I think the interests of the employees are relatively weak here. Remember, they're not paying for political expenses. They're only paying for collective bargaining and contract administration. In addition to that, they're not barred from communicating their views to the employer. They can't bargain directly with their employer if the union is the exclusive representative, but they can communicate their views to the employer, and they can actually go to any sort of public meeting about the collective bargaining agreement and stand up and say, I object to what the union is doing here and I disagree with that. And the Supreme Court has held that they have a right to do that, even though they are represented by the union. So they have that right. They also have the right to get rid of the union. If a majority of the workers don't want the union anymore, there is a process in these laws for them to vote out the union. So I think the interests of the employees are relatively weak. And also, if you look at what these union contracts cover, while the plaintiffs argue that they're very political, that these issues are political, in fact, a lot of what we're talking about is things like how you allocate overtime or how you allocate leave time or even how you allocate offices, who gets which office. So much of what is covered here, I think, just can't be characterized as political at all. At the same time, the employer has very strong interests in this labor relations system. And they've designed this whole system, and it's kind of unique to the United States and a couple of other places, but this exclusive representation system that balances the interests of employers and employees and unions for purposes of labor peace. And the state has a strong interest in that system, and this is a piece of that system. The other aspect of it, I think, that sometimes gets lost is there are union members whose First Amendment rights are burdened if they have to pay the costs of representation for workers who choose not to pay. If there was no fair share, then those people who chose to pay for union representation, the resources of the union to speak politically on their behalf are reduced because their dues money is being used by the union to represent for free, essentially, those workers who choose not to pay if you didn't have this. So there's a burden on First Amendment interests either way, and where the state has made a choice to adopt this system to balance all those rights, I think given the decisions of the court with respect to the rights of government employers, that's really where the balance falls. Having said that, I don't know that that's where this court is going to come down. I mean, given what Justice Alito has said, there seem to be at least several justices, and a lot of people think there are at least 4 justices that want to overrule Abood. They did not do that in Harris. They could have overruled Abood in Harris. They did not. The question is why? Did they not have 5 votes? Do they have 5 votes now that the case is back before the court? Or perhaps we'll see the court adopt this fallback position, this opt-out is a burden, and so employees have to opt in. Either way, I think if the court accepts either of these, it will be a blow to finances, to union finances. And even if they rule for unions here, this issue will be back before the court again at some point, I'm sure, because there are organizations like the National Right to Work Foundation that litigate these cases. It's not workers that are paying to litigate these cases. It's a group of various nonprofit organizations, most prominently the National Right to Work Foundation. So these cases will continue to be before the court on a regular basis as a result of that.
Before we move on, does anybody have any thoughts, predictions?
One quick question.
Okay.
Will this apply to private sector unions as well, or does it depend on what ground they go on?
Well, this case involves public sector employees. I think we might see a follow-on case involving private sector employees, but for right now, this case will only apply to public sector employees. The same system is used in the private sector. It has been upheld in the private sector as well. The cases that upheld it are pretty old cases, and there's a lot of discussion about whether there's really any state action involved in, although the court held that there was years ago. But I think that's an issue with respect to the private sector as well that we might see if a private sector case
That would help
comes
the
back.
unions rather than, if there was no state action, that would help the unions, would it not?
Absolutely.
Yeah, I was just going to say that, boy, it seems to me as if this is one where the writing is on the wall. I mean, if you look at the opinions in Harris versus Quinn, they are basically opinions on the pros and cons of Abood, and I suspect that if the court ends up overruling Abood, we'll see essentially the same opinions and probably the same justices writing them in Justices Alito and Kagan. Having said that, that was precisely my view on the fraud on the market presumption when the Supreme Court granted review on that issue in the Halliburton case, and the court stepped back from the brink and did not overrule that presumption, which just goes to show that predictions are a dangerous business where the Supreme Court is concerned. I do think that this is a case in which if I had to guess, and it's very much a guess, I think that the court would have overruled Abood, but for the fact that that issue was not expressly in front of it in Harris. The court did essentially invite a test case, and sure enough, here we are a couple terms later with precisely that test case. And so I tend to think that the court already has a pretty good idea of what it's going to do on this issue, but we shall see.
We'll see.
And I would just add that I think over the course of the Roberts Court's 10 years, it's often been a question at the outset of the term, is the Roberts Court radically conservative, sort of capital C conservative, or is it sort of small c conservative, moderately conservative? Will it overrule precedents, or will it step back? And most years, the answer has been it's been a moderate conservative court. It has, with some notable exceptions, starting with Citizens United, but for most years it's stepped back rather than step forward. Now, of course, last year was the first year in its 10 years that liberals won more 5-4 cases than conservatives did on the court. And the conservatives were not happy about that, as you saw from the tone of their dissents. They're not used to losing, and they weren't happy about losing. Maybe that will drive them to be more big C conservative this time around. But I think historically they have been small c conservative, and that would suggest going with the sort of fallback opt-out, opt-in issue rather than overturning Abood. But again, predictions are a dangerous thing, and Cannon's probably right.
All right, we're going to segue from the First Amendment to the Eighth Amendment. The court closed out last term with a decision rejecting a challenge to Oklahoma's lethal injection protocol, but the Eighth Amendment is back at the court in a couple of different cases, and David's going to talk about 3 of them, all of which hail from Kansas. Kansas versus Gleason, and then just to keep us all on our toes, the 2 Kansas versus Carr cases. The Carr brothers are at the Supreme Court this fall.
So yeah, I'm also going to talk about Hearst versus Florida very briefly because it's the same sort of set of issues really. All 3 cases involve challenges to capital sentencing procedures, and they arise at a critical moment in the history of the death penalty in this country. As you know, the United States is one of the few developed countries in the world that still executes human beings. Most of the world considers it a human rights violation, as Pope Francis recently reminded us. But we're ambivalent about this practice as a nation, and that ambivalence has been manifested in a real drop-off, pretty dramatic drop-off in the incidence of executions. In 1999, there were 98 executions in the United States. The number dropped pretty much every year since then. Last year, there were 35, and this year there have been 20 thus far. And the same thing is true with the number of death sentences. That's executions. Same thing is true with the number of death sentences actually handed down. In the 90s, juries handed down about 300 death sentences a year. In the last couple of years, it's been about 80. Last year, I think it was 72, actually, but the 2 years before that, about 80. And then, of course, last term, Justice Breyer, joined by Justice Ginsburg, invited a constitutional challenge to the implementation of the death penalty, essentially saying that the likelihood that you will be executed is arbitrary. If you are a murderer, is arbitrary. It's like being struck by lightning. And study after study has demonstrated that the things that determine whether a murder defendant lives or dies are much more likely to be race, geography, and the quality of his lawyer than the culpability of his conduct. DNA evidence has demonstrated that notwithstanding all the procedures that we lard up the capital scheme with, we make a lot of mistakes. 115 people convicted and sentenced to die have been demonstrated by DNA to have been innocent of the crime. Not just not deserving to die, but innocent of the crime. And so I think there are real serious questions about our continuing willingness to allow human beings to put other human beings to death. And none of the cases that the court has taken this term really directly raise that question, but they all concern the procedures by which we make the decision about whether someone lives or dies. Hurst versus Florida is a Sixth Amendment case, and the two Kansas cases are Eighth Amendment cases. In Hurst versus Florida, the question is really whether the judge, rather than the jury, can make the findings that warrant the death penalty. The Supreme Court has said that, that the way that the death penalty can be implemented constitutionally is through a separate penalty phase at which the state has the burden of demonstrating beyond a reasonable doubt the existence of specific aggravating factors, things like you killed a police officer, or it was a particularly heinous murder, or it was felony murder, or things like that. Something that lifts this murder out of the 15,000 murders that occur every year and puts it in a category where it deserves the 80 that actually get the death sentence. So that has to be demonstrated by the state by beyond a reasonable doubt standard. And then the defendant is entitled to put in any evidence about himself and his character, et cetera, his upbringing, anything that would mitigate. And then the jury is required to weigh the aggravators against the mitigators. In Ring versus Arizona, the Supreme Court held that the Sixth Amendment right to a jury trial requires the jury, not the judge, to make the finding of aggravating factors that lifts the case out of a non-death case into the category of a death-eligible case. Florida does let a jury opine on that issue in its procedures, but it's an advisory role that the jury plays. So you have a separate sentencing phase. The state puts on evidence about aggravating factors, but then the jury is told, you just have an advisory role here. It's the judge who will actually determine whether there are aggravating factors, whether what the mitigators are, and whether the aggravators outweigh the mitigators and death is warranted. And so the question is whether having the jury engage in this advisory role without making specific findings that any particular aggravating factor has been accepted is consistent with Ring versus Arizona. It certainly doesn't seem like it's consistent with Ring versus Arizona. And the case is particularly disturbing in that Florida doesn't require the jurors to indicate which aggravating factors they found. In this case, two aggravating factors were put forward. The jury voted 7-5 in favor of advising for death. But we don't know whether it could be that that on each of those two independent factors, three members of the jury might have thought there was one aggravating factor, and the other 9 thought no. And on the other aggravating factor, 4 of the jurors might have thought that aggravating factor was established, and 8 thought no. But that would still be 7-5 in terms of, is there any aggravating factor that authorizes the death penalty? So it's a disturbing procedure, and it seems, I think, highly unlikely that the court is going to uphold it. The Kansas cases involve 2 questions. The first is whether the jury has to be told clearly that in assessing mitigating circumstances, it's not supposed to apply the beyond a reasonable doubt standard, particularly in a situation where the instructions are unclear and they're told many times that they must apply beyond a reasonable doubt standard to the aggravating factors determination, and the jury's instructions are just silent as to what standard they should apply to mitigating. And there's it's clear that you can't require the jury to find mitigating factors by proof beyond a reasonable doubt. That's as a legal matter, that's a burden that applies only to the government. It's not a burden that applies to the defense. But the argument in both Kansas versus Gleason and Kansas versus Carr is that the jury instructions were not sufficiently clear about this, and so the jury might well have been confused and might have discounted mitigating evidence because they didn't think that there was evidence beyond a reasonable doubt that that mitigating factor had been proved. On that issue, it seems, what's the harm of requiring jury instructions to be clear about this? And the notion that juries understand clearly what their various burdens are when they're not told, I think, is a myth. And then finally, Kansas versus Carr, it raises that question, but it also raises the question of whether, at least in this case, the defendants, 2 brothers, were entitled to individual penalty phase determinations. They were tried jointly for a horrific, just brutally horrific series of murders. I'm sure Justice Thomas will regale us with all of the details in his separate opinion. Any of you who saw his response to Justice Breyer last term when Justice Breyer said, we don't really know whether the most culpable people have been executed, Justice Thomas responded by just recounting some of the facts of some of the cases that had been before the court that term, and they're stomach-turningly brutal. Well, this one is too. 2 brothers, a series of sexual assaults, execution-style murders, and the like. They're tried together, they're convicted, and then the question is, can they be sentenced together? And the argument is that where the brothers present antagonistic evidence, that may undermine the requirement that the jury make an individualized determination of whether each individual deserves death. Essentially, Reginald Carr is the big brother and was, by many accounts, sort of the leader and very deeply antisocial, and obviously, and the argument made by the prosecutor with respect to Reginald was that he is a deeply disturbed, dangerous person because of his genetics and his upbringing. Well, who shares his genetics and his upbringing? His brother, Jonathan. And so Jonathan is arguing it's not fair to try me with my brother, and Reginald doesn't think it's fair to be tried with Jonathan either, because part of Jonathan's defense is Reginald is the bad guy, the big brother. It's always the big brother. Speaking as a big brother, it's always the big brother's fault. So there the question simply is, should you have to have individualized hearings? I wouldn't hazard a guess on that one. There are sometimes good reasons to have joint hearings, not just efficiency. But at the end of the day, it may well be that the court, if it's going to keep the death penalty, which I think it will for the foreseeable future, will be inclined to adopt minor clarifications of rules that ensure that we, or reduce the risk that we send the wrong people to death.
You have.
I can't help myself.
Okay, you're from Kansas too.
I have a couple very quick thoughts.
All right,
yeah,
very quick.
Both as someone
We're
from
behind.
Kansas and as someone who's done death penalty cases on both sides, I mean, I agree with David. What we're seeing in the country at large is a diminution in the use of the death penalty, which I think is attributable, at least in part, to the fact that juries are simply not returning death sentences as frequently as they did, though there are obviously other contributing factors to that. And I think in terms of the way the Supreme Court approaches the death penalty, the Supreme Court, I think, has largely cut back on the use of the death penalty, and in part it has done so by taking what would otherwise be established legal principles and applying them and looking at their application quite closely in capital cases. And so I had this case a couple years ago, Smith versus Kane, where the court took a pretty typical issue involving a failure to disclose exculpatory evidence, but reversed a lower court ruling because the lower court had misapplied that familiar Brady principle. The court has one case on its docket, which David didn't talk about, Foster versus Chapman, which I think is in that category, a case involving Batson and the use of racially prejudicial jury strikes, and I think that's a case that's in that category. I actually think the Kansas case is a rare case in the opposite category, a case where I think the court is going to be correcting an error by the Kansas Supreme Court, a fairly defendant-friendly court, on this issue of whether this additional instruction is required. I think the court's Lockett-Eddings cases pretty clearly do not compel that additional instruction. I think the court took that case because of what the Kansas Supreme Court had done, which was, interestingly enough, to invalidate the first death sentences that had been returned in the state of Kansas, my home state, a fairly conservative state, since the death penalty was reinstituted. The last thing I would say just very quickly is that very quickly is that there's been a lot of talk about whether the court would take the additional step of saying that the death penalty is unconstitutional. Justice Scalia gave a speech just last week in which he expressed the view that the court might very well take that additional step. I think the reality is that that's going to require changes in the court's membership. If President Sanders replaces two of the more conservative members of the court with more liberal justices, then I think it might very well happen. But at least for now, I do think that there is a solid, albeit 5-4 majority for preserving the death penalty.
Thank you. We are going to stay with Kannon for another case out of Texas called Evenwell versus Abbott, which involves the principle of one person, one vote, which sounds very straightforward and yet is a little more complicated than
it turns
might
out
seem.
that it isn't. So we're marching through the amendments, and we turn now from the 1st to the 8th to the 14th. I don't know if we have any cases involving subsequent amendments to talk about, but this case involves the so-called one person, one vote principle, though I think the issue in the case may very well be whether that's an accurate or inaccurate moniker. So this is, of course, the principle from the line of cases between Baker versus Carr and Reynolds versus Sims that essentially says that there is a constitutional right not to have your vote, the force of your vote diluted, which is to say that you have a right, if this is in fact the correct characterization of the right, to have a relatively equal in population voting district so that your vote carries a comparable amount of force. And the specific question before the Supreme Court is really what is the denominator in evaluating the equality of districts? And in calculating whether districts are equal, are you looking at the total population of districts? Are you looking at the population of actual voters, or are you looking at something in between? And the argument being made by the challenger, who is a voter in a state legislative district in Texas, they're challenging the state districting, obviously, under this principle. The voter makes the argument that this principle is really all about the power of the vote. and you therefore have to look at the voting population in order to assess whether there has in fact been a violation of this principle of equality. And the case, I think, really in large part turns on whether that is in fact the correct characterization of the principle, or whether the principle is instead about representational equality, because after all, even if you're not an eligible voter for whatever reason, whether it's because you're underage or because you're disqualified as being a felon, or whether you're an undocumented immigrant, whatever the category of individuals, they obviously have a right to representation, and you could argue that that right is, in fact, the right that is diluted by unequal districts. The Supreme Court's precedents do not shed a lot of light on this issue. There's a lot of discussion about a case called Burns versus Richardson, which involves Hawaii, which is a somewhat unusual state because Hawaii has a large population of military and other individuals, and so the way in which redistricting operates in Hawaii is arguably different. The parties dispute what the court said when it essentially upheld Hawaii's decision not to use total population as the relevant denominator. But I think that this is really a sort of a fascinating case for law geeks of any persuasion, because it really involves the question of what this constitutional principle actually means. And the challengers make the argument that it should be the voting population, but they also argue that a state has some degree of leeway to take representational equality into account, I think in an avowed effort to avoid articulating too hardline of a rule. The state, on the other hand, in a brief filed by the state attorney general, who is, of course, a Republican, the state argues that it essentially has complete leeway in this area because it argues that vote dilution is really about invidious vote dilution, and how can you have invidious dilution when the state is using a sort of neutral consideration, total population, in making these determinations. I think the argument that the state makes that may very well end up carrying the day is that once you get away from total population as measured by census figures and other readily administrable figures, it's just very hard to calculate voting population or any of these smaller categories of individuals, because that data, those data are simply not kept, particularly when you're dealing with state legislative districts and you're therefore dealing with this issue on a relatively macular basis. I have to admit that I find this a very hard case to predict, I think precisely because there are so few relevant data points. I've heard it suggested that the challenger's position would help Republicans because of the peculiarities of redistricting. I have to admit that I'm not enough of an expert on this issue to know whether that is true as an empirical matter, but I think the real question is how are the justices going to react in revisiting this constitutional principle, which has when the foundational precedents really don't speak to this issue at all.
Well, I know Alan wants to chime in. I'm just going to point out
I'm
that
taking away from my own
you're
time.
taking away from your own time. You read my mind. Go for it.
Point one, I don't know the mathematics of how this will work out, but I do know one thing. Edward Blum is financing this case, and he also financed Fisher. So that probably tells you something about what he thinks the outcome is going to be. The second is that the plaintiffs have said that the test should be one person, they should have voters or potential voters. Now, that's really squishy. When you try to figure out who is a potential voter, and as Kannon said, the voting records are terrible in terms of registration, people moving around. And the third, and so that presents us third problem. And the state of Texas has said, we think this is okay, but in fact, what we really think is the state of Texas gets to choose and can change its mind from time to time as it sees fit, so that the potential for legislative manipulation around as they go from one standard to the next could be a really big problem in this case. It's very hard to see how it's going to come out. The Burns case, which Kannon mentioned, was only on a short-term temporary basis when they were trying to deal with the fact that one person, one vote had come in. And Hawaii used to have legislative apportionment by islands. with most of the people living in Oahu, and they were told they had to change that around, and so this was what they were going to do in the interim. The Supreme Court approved keeping the military out at a time when the military was much larger percentage of the population than there now is in Hawaii.
And it was military and seasonal tourists,
Yes,
which
yes.
sort of raises the question of whether this case would have been mooted if they had the election in June rather than
Well, and
November.
also with all the people coming in from Asia at the time as well, so that would have been quite interesting.
Not to take away from Alan's time, but just very quickly, I don't think that most folks who are following this case dispute that it has a racial aspect of it. It's important to point that out, that if you use the criteria that the plaintiffs are advancing, you end up with whiter districts, with richer districts, and we have to pay attention to who then is getting excluded from those districts. And if you truly want to advance a representational sense of an inclusive sense of representation, if you do not use all residents, you're excluding people who, for many reasons, cannot vote or are unable to register to vote or are permanently banned from voting. And we have to look at this against the backdrop of the increasing number of very restrictive voter ID laws that are popping up around the country. That we don't disconnect the one person, one vote issue from the race issues that are really a part of this case as well.
All right, and with that, let's turn to Alan for the last. It's a trio of cases that I think many in this room would describe as access to justice cases, that the other side would describe as due process for and defending against frivolous lawsuits against corporations. So Alan is going to kick it off.
These
and
are
then we'll
all
open it up.
about mostly class actions. The first case is Tyson's Food. It's a Fair Labor Standards Act case involving the question of overtime pay at a meat processing plant in Iowa. I won't burden you with the difference between the Federal Fair Labor Standards Act and the Ohio Fair Labor Standards Act in terms of class actions versus representative actions. I don't think that will ultimately play a thing in the difference in the outcome. The main question is the defendant argues that lots of people for whom this judgment was entered, is about $3 million times 2 against Tyson's for allegedly not paying for overtime. In fact, the people who are not entitled to it are getting paid, and they're complaining about that. They say it's unfair that should happen. The second issue in the case, which when I saw the petition, I thought it was really the first issue, was whether a class as defined in the certification order can include people, some of whom will not actually turn out to be entitled to get any money. That issue now appears, from what the defendant has said, is really not much of an issue in the case, because they've conceded that you have to allow at the beginning of the case to have a class with people who may or may not be entitled to recovery. Otherwise, first, the defendant can't get res judicata because those people will have to be excluded. And the second, of course, is you can't settle cases if everybody has to be entitled to recovery, because you can't figure out who's going to get recovery. And the last, of course, is at the beginning of the case, you don't know who's going to be entitled to recovery. If you have a promotion case, there are 5 vacancies and there are 50 people in the class, only 5 people are going to be entitled to recovery, but you have to put all 50 in there so you can tell who's going to be in the case. All right. So the big issue in the case is how to go about calculating this overtime, and whether this trial plan, which the district court approved and which actually went through the trial, was satisfactory and consistent with the predominance requirement for B3 class actions under Rule 23. And the problem for Tyson's was that it was required by the statute to keep detailed time records of when men and women went to work. But Tyson's not only didn't do it under the statute, but there was a court order directing him to do it. And this time that's in dispute has to do with the taking on and putting on and taking off of their protective equipment and other equipment needed for work, and the time walking from the area where they work to where they change their clothes to the time to where they work. And then there was an issue about meals, whether the meal time would count. The plaintiffs contended that the meal time was artificial and that really was just for Tyson's benefit, and the jury rejected that. So this is not a case where the jury went all out for the plaintiffs. They went the other way. Well, Tyson said, look, we in essence have to have a trial for each of the 3,000 people who work in this plant on damages issues. There were trial on liability issues. Tyson lost all the claims on liability. They said it was work and they were compensated and they were not, didn't violate the Portal Act. 3 big legal issues, all of which Tyson's lost, and it's not challenging those legal issues in the Supreme Court. It basically is saying that you couldn't have, the term is used from the Walmart case, trial by formula. And the first answer that the plaintiffs give is, look, the reason we're having this trial by formula is because you didn't keep the records you're supposed to keep, and if you had kept those records, we could have used your records to, as the law requires, to determine exactly what it was, and there wouldn't have had to been a trial at all. We could have just done the math. And the second thing they say is, look, this is not a case where we're trying to apply it to everybody on a single basis. We had a study done. There were 734 observations of the actual time. It took different people to do different steps in the process. You had a full opportunity to cross-examine these witnesses. You did not have any Daubert challenges to them. You didn't object to the jury instructions. You just didn't like what happened in the end. And therefore, the reason we had to do all this is a perfectly valid reason. The trial judge had control over this, and there's no more money, as evidenced by the fact that the jury cut the demand basically in half, that Tyson is paying any more money than it should be paid. So a couple of questions arise. First, why did the court take this case? Well, one theory is to do mischief, okay. Second theory is this is like Comcast a couple of years ago where they thought they were going to do something big, and when they actually got down into the record, they found out that the questions were not presented the way they were there. Third is maybe the court is going to actually start to get in not on these big issues about class certification, but actually think it's going to manage the trial process better than the trial court judge and the Court of Appeals. That would be another form of mischief. But it's entirely possible that they may just simply dismiss the case as improvidently granted when they actually get around and see what Tyson's is asking them to do. All right. The second case, as we near the end of the baseball season, I refer to it as the pick-off case. This is called Campbell-Ewald, and I'll simplify it, but in essence what happened is this is a class action case, and the plaintiff filed the complaint, and the defendant comes in shortly afterwards and says, I'll give you everything you're entitled to get, including your filing fees and all your damages. In fact, I'll give you more than that. And now we're going to dismiss the case. And by the way, the class action goes away because you're the only class representative. Now, there are along the way some questions about whether they actually offered everything. That the plaintiff says, look, we demanded attorney's fees in this case, and since we had drafted a class complaint, A, you didn't offer attorney's fees at all, and B, you should have offered them for us for the portion of the class complaint. But the real issue in the case is when you have in this case, it was an unaccepted offer, and the plaintiffs are saying that's not enough. The case started off as being a Rule 68 case. I don't think it has anything to do with Rule 68. That argument is basically dropped out of the briefs. But in the end, the question is, if the defendant had actually offered full compensation, because that's the case that's going to come up, somebody's going to perfect their offers in the next round, can the defendant get rid of the cases by picking off all the class representatives in cases where the class representatives' claims are, I think in this case was $150, I may be wrong about that, but quite modest amounts, and do that and keep doing that until they run out of class representatives. And this is the potential case, and I don't know what the court is going to do about it. They could get around it by saying, well, you didn't actually offer them everything this time, and the offer was not kept open long enough, and so forth and so on. But I think those are just simply postponing the inevitable, and the real question is whether the court's going to allow these kind of maneuvers to go forward, and the pick-off plays will succeed. The third case is a case called Spokio. It's under the Fair Credit Reporting Act. There are statutory damages, and the plaintiff has been unable to show any particularized injury from the violation of the Federal Fair Credit Reporting Act. There were some inaccurate statements made. The defendant says, we didn't violate the law, but moreover, you have no injury, and you cannot use the federal courts, despite the fact that Congress has provided statutory damages for you, to get in and get this adjudicated, by the way, on a class action basis. And the court had this issue a couple of years ago. The case was argued in October, and the last day of the court, the case was dismissed as improvidently granted on a 4-4 basis. And who knows what's going to happen again this year. If Yogi Berra is right, the predictions are very difficult, especially about the future. This is really one of the problems that you're going to have in this case. And I don't think anybody knows what the court is going to do here.
I think several of these cases are really important for employees, particularly under the Fair Labor Standards Act, because that's an area where we're seeing more and more class actions on the part of plaintiffs. In fact, that's a growing area, and I think we see as many, if not more, of those cases than discrimination cases these days in the class action area. And if these class and collective actions can't be brought, in most of these cases, it's a relatively small amount of damages for each employee in terms of not paying overtime, those sorts of issues. And these cases really have the potential to cut back on or eliminate those class and collective actions for employees, which of course would benefit employers.
I mean, I would just say in 2 sentences that these are very interesting cases at an impossibly high level of generality. They all involve the question of whether a class action can go forward when there is no injury of one sort or another, whether it's a case like Campbell-Ewald where the named plaintiff's injury has basically disappeared because the plaintiff has been fully compensated, whether it's a case like Tyson Foods where it appears that some but not all of the plaintiffs have suffered no injury, or whether it's a case like Spokio where the plaintiff may have suffered a statutorily created injury but may not have been actually injured in a very real sense. And given the current Supreme Court's tendency to rein in class actions, I think there's a good chance that those cases will largely come out in defendants' favor, though as Alan points out, there are complexities to each of those cases, and I think there are real complexities about how far the court would be willing to go in any of the 3 of them.
All right, well, I just got flashed the sign that says it's time to move on to questions, so it was great timing. And there's a gentleman here with a microphone, so please raise your hand. 2, a gentleman and a lady, woman with a microphone, so.
Hi, on the voting case, does the briefing there address the 3/5 compromise as a guide to interpretation of intent?
Well, I didn't see any discussion of that, but I also didn't make any effort to go through all of the amicus briefs. So.
I did look at a few of the amicus briefs, and I didn't see any discussion of that. I don't recall any discussion.
So there's a related question, which is, it's pretty clear, I think, from the Constitution that the House of Representatives does talk about people rather than voters. And the question is, since one person, one vote, or the principles of Baker against Carr and Reynolds against Sim have been generally applied, although not precisely the same way, to both congressional and to state legislative elections, whether the court will say, look, the framers, to the extent they were unclear about it, they mean to use the same thing, and it would be quite odd if you drew districts one way for Congress and drew them quite another way, and or the state choice for state and local elections.
And of course, at the risk of being quaintly textual, the Equal Protection Clause itself speaks only about persons, and that has been broadly construed in other contexts.
Hi, my name's Elaine Middleman. I learned from watching the Republican debate that Chief Justice Roberts is either too liberal or not qualified to be on the Supreme Court. And of course, I'm kidding. But do any of you think, I mean, I find that very troubling. It's really almost a personal attack on him. And do any of you have an opinion about if hopefully he won't, crumble under that pressure or somehow alter his views? But it just really seems uninformed.
I'm not going to touch that with a 10-foot pole.
Well, I don't think you'll pull a John Boehner and resign, if that's the question.
I think the justices have life tenure, and so they can withstand such criticism.
I'm Mike McGough from the LA Times. On the Fisher case, this is for Deborah Archer or anyone, how important in justifying racial preferences and claiming a compelling interest is it that the University of Texas Law School is a feeder to positions of leadership in Texas and the Texas legislature? Would it be different if it's a national law school where you can't argue that we're sort of grooming the leaders of this state? These are all people who are going to go out to the four winds and go somewhere else. Does that matter?
I actually think the argument applies both for state universities like the University of Texas and feeder law schools like Harvard Law School. That, and I think in the Grutter case, there were amicus briefs on this issue from leaders in corporate America, from government officials, from the military, that it's important for us to keep the doors of opportunity open for everyone, because we are grooming leaders, and not only do we want to make sure nationwide, not only just in Texas, but nationwide, and not only do you want those leaders to reflect the community, you want those leaders who may not be themselves minorities to understand and be able to engage in a multicultural environment, and they can't in an all-white institution. And just about the feeder and opening opportunity, we've talked a little bit about why the Texas Top 10% plan is not a great thing for diversity or a great thing for the University of Texas, but I think it's important to mention that it is opening a door of opportunities to some other students who would never have those doors open. Those minority students who are attending racially segregated schools and getting inadequate educations, they're getting an opportunity now to go to the University of Texas. And that opens doors that would not have been open for them otherwise. So in many ways, Texas is opening doors, I think. But that both the Top 10% plan and their race-conscious programs are important in opening those doors.
By the way, it's not Texas Law School, it's the undergraduate thing. And also, the top 10%, of course, won't work except if a state is really trying to get in-state people. That is, obviously, Harvard couldn't do the top 10%, and University of North Carolina attracts a much larger percentage than Texas does of people outside the state. I don't know what it was when you were there.
I think it's an 18% quota.
It's a cap, yeah.
In-state.
Out of state.
Oh, out-of-state.
Out of state.
It's only a matter of time before someone challenges that.
I think we've got some in the front row, please.
I'd like to ask about a case that hasn't come yet, the Texas versus U.S., the extended DACA and DAPA. We've heard a lot of predictions about how late a decision can come down from the Fifth Circuit in order to make it into the Supreme Court's next term. I was wondering if anyone had any predictions about that.
I'm the moderator,
Well,
don't look at me.
it depends what the court wants. I had a case that was granted, well, the New York Times, the Pentagon Papers case, of course, was decided in May and June and was heard. I had a case that was granted and it was decided in the lower court in April. And it was granted and heard the end of May. So, if they want to, they can do it. But I'd be surprised if it goes that long.
I mean, even if the Fifth Circuit were to decide it tomorrow, it'd be pretty hard to make it on for this term unless somebody tried to speed it up.
Well, which the government almost certainly would do if they rule against the government, even though it's only on a preliminary injunction.
Yeah, maybe.
We'll find out. There's somebody that's over here.
Hi, thank you. Dan Roberts from The Guardian. I just wanted to follow up on the question down here and relate it back to a point that David made. I think you were saying that this was a year where we might discover whether the court is a radically conservative court or a moderately conservative court. Does the panel think that in an election year this will play a role in the minds of the justices? I mean, we have, as I think one of the other panelists said, an election that may well determine the future of the bench quite significantly. Is it exaggerating to say that this is a crunch year for that formation of the bench in the long run?
Well, I think it is. I think this election is, I mean, every election people say this is about the future of the Supreme Court and the Constitution. This time it's true. You know, it's as we all, I don't think it will affect how the court decides these cases. I think if the court comes out with more radically conservative decisions this term, it's more likely because they've taken cases in areas where they have been pretty darn conservative, like race and affirmative action and access to justice. They've been pretty consistently conservative there. But yeah, as to this election, the court it's a 5-4 court. Kennedy is the decider on most matters, and if the next president gets to replace, if a Republican gets to replace Ginsburg or Breyer, just to the two oldest Democrats, that changes the court to a 5 solidly conservative court, renders Justice Kennedy irrelevant in most instances, and changes the nature of the court. If a Democrat gets elected and gets to replace Scalia or Kennedy, the two oldest on the Republican side, that also dramatically changes the court, and now you have a solid 5-4 Democratic majority. So, and given how old they all are, you know, it's not that unlikely, just actuarially, that the next president, particularly if the next president serves 2 terms, then it's virtually certain will make those appointments. So this is a critical time, I think, for the future of constitutional law.
David, if I ever have a case in the Supreme Court against you, I'm going to quote that last statement of yours on the first page.
This is off the record, right?
Except for the camera, right?
All right, I think in the middle. Reggie, okay, thanks.
Hi, it's been a fascinating panel. My name is Michelle Sohn. In terms of the Spokane case, it seems every week or every month there's another data breach, Target, Ashley Madison, Home Depot. And so I'm wondering if the court comes out and says in Spokane, no injury in fact, no standing, what the effect on larger data breach class actions will be. Will that just put an end, or will it just be a narrow sort of stop to just Fair Credit Report violations? Would love to hear your thoughts, Alan, on that landscape.
Well, I think to an analogy, if that actually happened, and if we had a Congress that was concerned about this, which we may or may not have, unless they realize it's their data that's getting breached, rather like in the Jones case a couple years ago when the Chief Justice asked an oral argument, you mean they could attach that bug to my car? And the government said yes, and that was the end of the case. But if I were thinking creatively, I would think that Congress could create actions rather like qui tam actions in which they would deputize private attorney generals who could bring actions that would recover money for the Treasury and get an injunctions against these and provide for attorneys' fees in that way. It seems to me that in that kind of situation, you could achieve some of this. You would not achieve the redistributive effect of having the damages paid out, but you could at least do something about getting bad practices stopped. But that's just off the top of my head. I have to think about it a little more.
I mean, the good news for the would-be Ashley Madison plaintiffs is that they're going to be exceedingly likely to be able to show actual injury as well as statutorily created injury.
And they said no John Doe plaintiffs in that case.
Yeah, that's the bad news for the plaintiffs.
Question about the lethal injection cocktail. Several members of the court seem to feel that those who were challenging the death penalty and putting some pressure on manufacturers not to provide certain drugs bore the burden of showing a fairer way to execute people. Now we have some states that are denying even FOIA requests to find out what the cocktail is.
Well, I don't know whether it'll work as a FOIA matter, but I would suspect it might be a little different if you're actually being about to be executed, you might have a discovery option that you wouldn't have available as a matter of a FOIA. I always thought that you have to have a saner way of executing people, or more perfect way. What about the firing squad? The problem is nobody wants to be on the firing squad, and with good reason.
That argument, I think, was one of the most heated arguments I've ever heard from the justices' side of the bench in the history of listening to arguments, and it only underscores what I started with, which is how deeply ambivalent we are as a nation about the death penalty.
Thank you. Any sense of what cases might come out of the long conference?
Ask us again at 10 o'clock tomorrow morning.
It is not packed with headliners, I will say. I think everyone is waiting on the birth control mandate, which will probably be there sort of the middle of the year. There had been a string of decisions by federal courts of appeals upholding the accommodations against the challenge by the religious nonprofits. But then the Eighth Circuit last week or the week before struck it down and ruled in favor of one of the nonprofit groups. So that is almost certainly headed to the court. Probably by January is the cutoff, at which point the court usually takes cases for the rest of the term. So it could easily make it by that point of the term.
And likewise, the small matter of abortion may be back on the court's docket. Though that is, I don't know what the timing is of the Texas case. Do you?
The
petition's been filed.
Yeah. So there was the Mississippi case challenging the admitting privileges, and that one's been on hold since the spring, waiting for the Texas case, in which the Fifth Circuit rejected the challenge to an admitting privileges requirement and then a requirement that clinics have the facilities equal to a surgical center. And so that petition was filed September 2nd. The brief in opposition is right now due the 5th, I believe. So that could be sort of November, December, depending on whether or not Texas takes an extension.
They haven't taken any Fourth Amendment cases that I'm aware of, but there is a case out there. There's a split in the circuits out there on cell phone location data and whether the government can get cell phone location data, which is extraordinarily useful in investigating crimes, without having to have probable cause or individualized suspicion. And this is a huge question that implicates all of the data, as a constitutional matter, implicates all of the data that all of us are generating every minute that we walk around with our cell phones and use our cell phones, because we share that whatever information we put in our phone, or even where our phone is, or who we're communicating with via our phone, with some third party. And there's an old rule from the pre-digital era that holds that if the third party has information, the government doesn't have to have any individualized suspicion or probable cause or a warrant to get that information. In today's world, that's everything about you, and so it's presented in these cell phone location data cases where the 11th Circuit has said third-party disclosure rule, no warrant is required. It doesn't matter this is the digital age, and the Fourth Circuit has said no. This does in fact invade a reasonable expectation of privacy. So that will be, if that goes up, that will be a very big case for the future of privacy in the digital age.
And it is 2 o'clock and 47 seconds. All right, please join me in a hand for our great